This is case number 21-156-487. This is PCA Acquisitions 5 LLC versus Vernon Matthews. The matter is before the court, set on for a review on today's date. For the plaintiff in this matter, your appearance at this time.
Yes, good morning, Your Honor. This is Natasha Dixit on behalf of the plaintiff PCA Acquisitions V LLC. My P number is 82333.
All right, thank you, Madam Counsel. Good morning to you. Counsel for Vernon Matthews, your appearance at this time, if you're on the Zoom, please. Do I have Vernon Matthews on the Zoom? All right, Counsel, update me. What's going on with this matter? You know.
Yes, Your Honor. As an update, on October 25th, we did mail to Brian Parker, who is Mr. Matthews' attorney. We did send him a stipulation to dismiss all claims without prejudice. So we have sent that over to him. So once we, have that signed from him, once he returns it to our office, we'll send it to the court to be entered.
All right, very well. All right, with that, I will simply mark the file as pending dismissal, and the court is expecting an order in this matter. And that should close us out. I'm not going to set another control date or anything. Obviously, if there is any need for the same, then just send a notification, and the court will set it. All right, thank you, counsel. Good day to you.
All right, thank you, Your Honor. Your Honor, just to clarify, did you said the court will be setting a new date, control date, or just?
No, I'm not going to set. I'm not going to set a date on this. I'll just await the order. And the way that works is, if there's a problem, then you would want to send a request for a hearing date, and you could email that to the court at Latifah LA. TIFAH.hunter@36districtcourt.org. That's what you want to just email notification that you need a court date on this. You said otherwise I'll be waiting dismissal.
Okay, great. Thank you, Your Honor.
Thank you. Okay. The court now calls case number 21-156-457. This is American Medical Center versus City of Detroit. The matter is before the court set on for a pre-trial conference. Counsel, your appearance for the, first of all, do I have counsel for American Medical Center?
Good morning, Your Honor. Joe DeCurb on behalf of the plaintiff.
And your P number, if you will, for the record, counsel.
Your Honor, P84445.
Thank you, counsel. And for the City of Detroit, your appearance at this time.
Good morning, Your Honor. Robin Brooks on behalf of the City of Detroit, P47787.
All right, thank you, Ms. Brooks, and good morning to you as well.
Good morning.
All right, I know that this has been up a couple times before, and I also know that there is a motion for summary disposition that's before the court as well. All right, so anything else that needs to be brought to my attention before we take a look at what's going on with the motion?
No, Your Honor.
No, Your Honor.
Thank you. All right, so Ms. Brooks, this is your motion. So fears. And Ms. Brooks, you may proceed at this time.
Your Honor, I don't know what brother counsel, we just filed that. So I did you respond, Joe? Or
Your Honor, I'm my ears kind of perked because I'm frantically looking through my email and I don't see us having this MSD. I only show it as a pre-trial.
it is a pretrial, and you know, I give a number of different kind of notices. Sometimes I allow motions for somebody in this position to be heard when the other party has at least 7 day notice before the hearing. But this is stamped October 26th, and so thank you, Ms. Brooks, for bringing that to the vote. Yeah, so I probably need to give you a little time to respond to this.
Yes, please, Your Honor, if the court can be so inclined.
I didn't want Joe to be burning up my phone line.
Oh, no, I was like, I was looking and I'm like, oh my God, did I miss it? Where is it? It could happen.
I wouldn't do that to you, Joe.
Thank you, Robin. I appreciate that. I know you wouldn't too.
Yeah.
Very well. I didn't look at the date on it. I thought everybody was on the same page. As soon as Ms. Brooks said something, I looked at it. It has October 26th. So yeah. Yeah. All right. So I will go ahead and set this on for hearing. What's you need 30 days or 20
Your
days?
Honor, I don't need more than 2 weeks. And if you go into 30 days, Your Honor, I'm scared that we're going to be into December and I won't be here because I'm taking my family to Disney.
Well, I'm canceling your trip if it.
He's sending me a ticket also.
Well, there's too many of us. They won't let us fly. They don't allow us on a plane anymore with the 5 babies. They shove us all into the car and we go.
Sure.
Well, since you put it that way, never mind. I don't want to go.
Right.
Quite the ride. All right.
November 17th.
November
17th.
17th is the date I'm going to give you for this. That works for everybody. I'm thinking 10 o'clock a.m.
Okay. I do have a 9 o'clock before Judge Giles on the 17th. So hopefully, Judge Giles is very punctual, so I shouldn't have a problem, but I do want to put the court on notice if I'm a little late, that would be the reason.
Very well. So we'll set it at 10 o'clock or as soon thereafter as possible. Right?
Okay, great.
And Robin, please, if you could be so kind as just to email it to me.
Yeah, they sent it to the office, but I'll have them resend it.
Yeah, it'll take forever to get here. If you just send it to me, I'll accept it via email.
No, I'm the email and mail. I'll just resend it. I'll make sure you guys get it again.
Thank you, Robin.
All right.
It's too large of a volume to send my email. I'm kidding.
Right.
All right. Good day.
I got it, Judge.
He's still looking like, huh?
Right.
All right.
I know they're like that. I got it.
Good day. We'll see you on the next action date, 17th of November, 10 o'clock a.m.
Yes, sir.
Thank
Thank
you,
you very
Your Honor.
much.
You have a good day. Thank you, Robin. Nice seeing you.
You too, Joe. Bye-bye.
All right, this is case number 21-15-3722. This is Highland Tower Associates LLC versus Jacqueline Fears. The matter is before the court set for a pretrial conference. Counsel, your appearance at this time, sir.
Good morning, Your Honor. James Zellin appearing on behalf of the plaintiff.
All right, and Mr. Zellin, your P number for the record, if you will, sir.
P69241.
All right, thank you, sir. And do I have Jacqueline Fears on this Zoom? Say something if you're there, ma'am. All right, I see your lips moving. You do have to unmute yourself at this time. But like hit *6 or something. I think that would. You have not unmuted yet. Yeah, Ms. Spears, you need to press *6 on your device. That should get you off of mute. Or hit your unmute button. Oh, she's having a few connection problems there. One more. All right, Miss Spears, I'm not able to hear you because your device is yet on mute. If you will push *6, that should get you off of mute. Can't hear you because you're on mute. So if you look at your device where it has a microphone, if you tap where the microphone is, that'll take you off of mute. Stop talking, ma'am, until you get off of mute because you're talking. Something you're saying, I can't hear it. *6 should get you off. I see somebody's assisting you there. Okay, you might want to, since you're not able to get off mute, maybe what you want to do is hang up and call right back. Just dial back in. All right, Ms. Spears, you may want to hang up, ma'am, and dial back in. Just zoom back in. Hang up and then zoom back in, ma'am, because you're on mute and I can't hear you. All right, Council, I'm going to come right back to your matter.
Thank you, Your Honor.
And we're trying to work through this little hiccup. All right, this is case number 21149933. This is Michigan First Credit Union versus Maya Irby. Last name is I-R-B-Y. First name is M-I-N-Y-A. Now, the matter is before the court for a motion, like a motion for default. Your appearance at this time for the plaintiff.
Good morning, Your Honor. Weston Neal on behalf of Michigan First, P number 80307.
All right, thank you, Mr. Neal. Good morning to you. Do I have last name Irby on the Zoom? If you're on the Zoom, please say somebody at this time. Last name Irby. All right. So, counsel, update me on what's going on here. See, go ahead, sir. I'm sorry.
Sorry, Your Honor. Your Honor, there was some confusion regarding the status of this file. To just kind of give you the quick overview, defendant was served by attacking on July 6, 2021. We moved for entry of default, having not received an answer, which looks like it was entered according to the ROA on August 17th, 2021. And then we received notice from the court that the defendant had filed what we believe was a motion to set aside the default judgment. Since that time, we've received what looks like an answer. The answer is dated late as to a proper time to respond. But we've not received anything challenging the entry of judgment. So I'm not sure what the court's official status is, if there has been a default judgment entered or just a default entered. In either case, defendant not being here today, I would request that the court grant our default judgment and enter it against the defendant for the full amount pled in the complaint.
All right, I do see, it looks like Ms. Irby is present. Good morning to you, ma'am. Say your name for the record, please. Ms. Irby, are you able to hear me, ma'am? Is there something? Ms. Irby, if you can hear me, wave. Ms. Irby? Ms. Irby? I see her there. Ms. Irby?
That's muted.
Is her phone muted?
I mean, she's on mute, but she's not even responding to me or. Ms. Irby.
We had to something move to.
Ms. Irby? Are you able to hear me, Ms. Irby? Say something, Ms. Irby.
Put it on that so she can see it.
Yeah. Ms. Irby, if you're hearing me, push *6 to get off of mute, ma'am.
I put this up there.
Like she just. Morning, Ms. Irby.
She don't see that?
I don't know. There she goes. She talking.
Take it off.
You have to unmute. You have to unmute your device, ma'am. You have to hit *6 to unmute your device.
There again, can she see it? Did she read it?
She
No.
responded to it.
Yeah, turn up your volume, Miss Irby.
It's at 456663 number.
Oh.
All right, Mr. Neal, I'm coming right back to you. Ms. Spears, are you able to hear me, ma'am? You have to unmute yourself.
Hello?
All right, Ms. Irby,
Hello?
Okay, I can hear you now.
Okay. Yes, I was on Zoom this morning. I had an 8:30 meeting
who is this?
and something with the thing.
Okay, just, let me deal with, I'm back on the suffix, 9933, that's Michigan First versus, Minya Irby. Ms. Irby, good morning to you, ma'am.
Good morning, Your Honor.
Thank you. And the attorney for Michigan First is present in the Zoom. And the file has a couple of things. One is a document that Ms. Irby submitted to the court indicating that she'd like to file an answer. The other is the fact that on the 12th of August 2021, a judgment was entered in this matter by default. So there would have to be a motion to set that default judgment aside in order for the court to address that issue. Just one moment, I'm looking at a couple of things here. All right, so Ms. Irby, the document that you submitted as a proposed answer was submitted after the judgment was entered. Mr. Neal, do you have a copy of that document?
Of the letter submitted by the defendant, Your Honor? Yes, I do have a copy of that.
All right, just one moment. Let me look at this. All right, so while the court can't accept that document that you filed as an answer to the complaint because there's already a default judgment that's in place, you would have to file a proper motion before the court, Ms. Irby, and that motion would be in the nature of a motion to set aside the default, and you would have to show good cause for not answering timely, and then you'd have to provide a meritorious defense or something that you raise as a defense to the claim. I'm looking, counsel, did you treat that the letter as a motion to set aside the default?
Based on my understanding, Your Honor, from what I had heard from the court as well as the timing, that was my understanding that the court was accepting what was filed as a motion to set aside the default.
Just one moment. All right, so, I mean, a part of the problem here is that the motion, if this is a motion, it's not really properly before the court because it wasn't filed as a motion. But given that you've had a chance to read it and Ms. Irby has presented it, then let me hear what Ms. Irby has to say on this. Ms. Irby, of course, there's a default judgment that's been entered. That's because by law you did not respond in writing within the time permitted by law.
But Your Honor, I thought that I was responding in the time permitted by law. And the reason why I thought that was because, one, I was unclear of the
Do you really believe that? Do you really believe that you should interrupt me while I'm talking? I think you know that. So let me finish saying what I'm saying, and I'll give you the opportunity to talk. I'll give you that opportunity in just a moment. So you didn't respond in the time permitted by law. That happens a lot. A lot of people, they missed a date, 28 days to respond. You didn't respond within the time permitted by law. That's why the default judgment. You filed something essentially asking that the default be set aside. The law requires that in order to do that you establish good cause, number one, and number two, a meritorious defense. I've read the document that you presented, and I want you, I'm going to give you now an opportunity to tell me why you believe, what is your good cause and why you believe that the judgment should be set aside. Go ahead.
Well, one, I was unsure of when the actual court date was. I was unclear of exactly the date that the notice was posted on my door. I actually called 36 District Court to ask, and I thought that I was submitting a letter within the time frame based on my conversation with a clerk at 36 District Court as well.
All right, ma'am. And what do you believe to be a meritorious defense that you would have in this matter?
That this was a wrongful repossession.
All right, counsel.
Your Honor, my response would be very straightforward. The court is aware that to set aside a default judgment, a defendant needs to, or excuse me, a party needs to establish good cause and a meritorious defense. Good cause being a reason that the court finds acceptable that the answer was not filed timely. In our motion, we've stated the summons and complaint clearly states the time frame for which a response must be filed with the court. This is not, something drafted by my office. This is a SEAO form approved by the state of Michigan and used in all the courts, stating the time frame which an answer needs to be filed. Given that the defendant has stated that she did receive the notice, she was just unsure as to when to file. The date that I have on the document that we are referring to, I believe, is 26th of July. I did not receive that till mid-August. Obviously, I'm inclined to believe the court did not receive that timely as well, given the fact that a default was entered. So in that instance, I don't believe there's sufficient reason for good cause to be shown. Additionally, a meritorious defense requires that a party show reasons substantiated by documentation that if the court were to set aside the default, that this is the defense that would raise and that there is merit in it. It's not just an arbitrary defense. The defendant's response seems to indicate that there is a default did take place on her payments, but she does not believe that the amount of time offered before the car was repossessed was sufficient for her to repay, I guess, the outstanding balance and redeem the vehicle. In my response to that, I would just say, Your Honor, we followed all requirements of the state of Michigan regarding any Vehicle repossession and collection, and I'm sure you're well aware, Your Honor, all our contracts state, you know, you do have a grace period, but 60 days is well outside of any grace period that any lender gives for redemption or to make a timely payment. So given that, I don't believe there a meritorious defense exists, and I would ask that the defendant's motion be denied.
All right, thank you, counsel. Ms. Irby, you get the last word on your motion at this time, ma'am.
Okay. He's saying that in 60 days. However, what actually happened was that I was assessed 60 days in charges in 1 month. I was already 1 month behind, and I was paying my car note. And I was assessed that because I got dropped from my insurance carrier. So when they finally sent me the letter telling me that I no longer had insurance coverage and that it was now going to become a part of my bill, when they sent me the notice, I was already 60 days past due. So if we can honestly take a look at my payment record and my payment history on when I was making that payment, you can see that the fee was assessed, those 60 days, that 60-day fee was assessed in 1 month to me.
All right, ma'am. All right, I've listened to the motion to set aside the default in this matter. And that motion, of course, is without an affidavit. The defendant raises the two challenges set forth by the statute that would have to be raised. One is the showing of good cause for not acting within the time permitted by law. And the defendant says that she didn't know when to respond. She thought she was responding within time. And those are really not good enough answers. But if I assume for the sake of argument that the defendant had a good cause, she missed the date to file the timely answer. If I assume that, then we get to the next prong, that is the showing of a meritorious defense. In this situation, what the defendant would have to show is that there was some new agreement that had been reached outside of the installment sales contract that would have prevented the agency from taking any action, such as recovering the vehicle, offering the vehicle for sale at an auction, or suing efficiency balance in this matter. There is not a sufficient showing here that there was an agreement that superseded the installment contract. The installment contract on a motor vehicle allows for the plaintiff to take action to recover the asset, to sell the asset, and to sue for a deficiency balance whenever there is a default. There's no question about it in this particular situation that there was in fact a default. Ms. Irby says that there was an agreement that superseded the contract that she had. She's not presented any such agreement to the court, and that would be something that would be necessary in order for the court to really be able to drill in on whether or not there would be a basis to set this default judgment aside. At this time, I don't see anything that would rise to the level of a meritorious defense. If Ms. Irby is able to secure a document showing that there was a separate agreement, that would bode well for her in terms of trying to get this set aside. But without that, and with the presentation of this particular motion that is not supported by an affidavit, not supported by any other documentation that there was a separate agreement that superseded the installment contract, then there would not be a sufficient basis to find that there was a meritorious defense. For those reasons, the court will deny the motion to set aside the default judgment. The judgment will remain in place. I will say to you, ma'am, that you have the right to file a motion again, or a motion to set aside the default, and the court will take it into consideration. You would have to support that with documentation, and you would have to support it also with an affidavit. So you still have the right to bring that motion. I think that somewhat in sending a letter to the court that maybe you didn't raise everything that you wanted to raise, and I wanted you to know that you do have the opportunity to file another motion, raise any other issues that you believe that you wish to raise in an effort to try and get this set aside. And I will review it. I will consider it. And if there is enough there, then you're entitled to have it set aside. There's just not enough there at this time. And that's why the motion is denied. I do wish you well. Thank you, counsel. And just send in the order and I'll sign and sign. Good day to both.
Thank you, Your Honor. You have a good day.
I'll give it to you. Okay, we're back on the record regarding Highland Tower versus Pierce. That's the subject 3722. And thank you, counsel, for your patience. Mrs. Ellen and Ms. Pierce had some technical difficulties, but she is present in this hearing. All right. So, counsel, I think you were updating me on what had occurred here. So, if you will, sir.
Your Honor, we were here for pretrial before. We've been unable to resolve the matter at this point. So I believe we just need to set further dates to get this matter before the court for a trial.
All right, very well. And I have received a form answer from Ms. Spears. Let me look at this for just a moment here. I see that there. All right, so I see the claim here is involving some approximately $2,400, and it looks like this arises out of some claims for damages after defendant vacated the premises, some leftover rent kind of thing. Is that what it is, counsel?
Yes, Your Honor.
Okay. And you all have talked about this, and there have been some discussions to try and get it resolved?
I believe we discussed it at the last pretrial approximately a month ago. We were unable to resolve it then. There's been no further discussions to resolve it.
Gotcha. All right, Ms. Spears, do you believe that you owe any money regarding this?
I believe she's on mute again.
You're on mute again, so go ahead and unmute yourself.
Okay, I did. Okay, I did. Okay, so when I left the apartment was clean. Everything was clear.
Let me stop you. You heard that real simple question of mine, right? My question, real simple.
Okay.
Do you believe that you have owe any money in this situation?
I owe money. Okay.
All right, now I want you to stop right there. It's very important that I take that a step at a time.
Okay.
Now, I can set this up to begin to move forward to trial. And of course, the court will weigh everything and then make a decision. Sometimes parties are able to achieve an outcome that they have control over when they're able to discuss matters and find out where they are and whether they can get to where they can get to. The plaintiff's claim in this matter approximates some $2,400. I am not speaking on their behalf, but I'm sure that short of trial, we might be willing to compromise on some of that amount. The question becomes, how close can the two of you get together? When you had discussions last time, was there any offer? Don't tell me any amounts. Was there any offer of any amount to settle the case at that time?
I do not believe so, Your Honor.
All right. And
okay, with me?
Yeah, I'm asking you. So they may.
Okay, with me? I haven't talked to no one. This is got the letter in court in mail and everything, but I haven't talked to no one about the cases, about the old damages and stuff. No, I haven't talked to anyone. I'm just here. I came in September, but they had the wrong court number. They had everything wrong for me, so I wasn't
Your
able
Honor,
to
if you want to put us in a breakout room, I'd be happy to talk to her today.
That's what
Okay.
that's kind of what I'm getting at. Just see if there's room to kind of get it settled. That's what I'm getting at. And if not,
Okay.
the court has
Hello?
other. No, you gotta wait, ma'am. I'm on another case now. All right, I'll be right
Okay.
with you. All right, Ms. Spears, I'm
Okay,
going to
thank
send
you.
to a breakout room with Mr. Zeller and to talk a little bit about maybe ways to resolve, see if we can resolve it. Okay.
Okay.
And
Excuse me again. How do I get to the breakout room?
yeah.
I'm so sorry.
1 second. You're gonna see something come up on your device that says
Okay.
go to room number 1. Okay.
Okay. Okay.
And when you see that, just go there and Mr. Zellen's gonna be there. All right.
Thank you.
You see it?
It's a join.
Yeah.
It's a join. Okay.
Hello?
Just hold on a second, ma'am.
Okay.
This is case number 21-160062, Southfield Neurological Associates versus Elizabeth Walker. The matter is before the court set for a pretrial conference. Do I have counsel for the plaintiff in this matter? Southfield Neurological? Do I have Elizabeth Walker?
Good morning, Judge. I'm here for the plaintiff for Southfield Neurological.
All right. I'll put your appearance on the record if you will, Ms. Francis.
Sorry, Snapchat Francis, P72322, Your Honor.
All right. Thank you, counsel. Good morning to you. Do I have Miss Elizabeth Walker on the Zoom? If you are, say something at this time. Elizabeth Walker. All right. Today is the daytime set for the hearing.
Hello?
Yes. Are you Elizabeth
I'm
Walker?
just trying to, no, I'm Elisha Reed.
All right. Just stand down now. You're not on this case, are you?
No.
Okay. All right. Just be quiet for a moment. I'll come right. All right.
Okay.
So this is, I see where the court signed a judgment by default in this matter. The court also received a letter from Ms. Walker, but it doesn't appear that she's here today regarding this matter. Any information that you have, ma'am?
Your Honor, we have been speaking with the defendant, going back and forth about settlement, but besides that, no other communication as to why she has not appeared today.
All right. Well, it looks like it looks like this judgment was not mailed out. It was entered on the 23rd of August. So I guess when we received the letter from Ms. Walker, the court just held on to it. So I will enter the judgment now formally by default, as requested, where the defendant has not appeared for the hearing. And default judgment is entered for a total sum of $1,841.55. And the court will update it as to entry as of today's date.
Thank you, Your Honor.
All right, thank you. Good to see you all as well.
You too, Judge. Bye.
Take care.
You let this earn it. I don't have a case for her.
Hey, ma'am, can you hear me?
Yes, I can hear you. I can hear you.
What case are you here on today?
Case number SP107-28432.
What judge are you here? Do you know the judge?
It says Deborah G. Ford.
Okay, so yeah, you got a bag out of here. You're gonna do 360-335 instead of 336. You're gonna do 335-0000.
Wait, hold on 1 second. So
Okay.
it says 360. So you said do 3 what?
So 360-335-000.
Okay. Thank you.
All right. You're welcome. Have a good day.
Okay. Spears, I see you found your way back. You're getting good at this.
Yes, yes.
All right, welcome back, Mrs. Ellett. Did you guys get anywhere at this point?
We did, Your Honor. I was able to explain what that there was a miscommunication with the legal artful term of damages, and she thought we were claiming some damage to the apartment, but it was just past due rent. So we were able to get past that. I'm going to send a consent judgment to the defendant. She's going to sign it and send it back to me, and we'll submit it to the court. If you just want to adjourn this or set a control date or something else, we should have this wrapped up here in the next couple weeks, as long as the mail gets there.
That makes sense to you, Ms. Spears?
Yes, yes.
All right. All right, then. I'll go ahead and send it over for a couple of weeks. I'll just put a control date on it. And that's gonna, I think we'll put it at the 17th of November. I think that's the day before. Yeah. All right, so you'll have it, let's get it in as soon as possible. The 17th of November is the date that I'm setting, and you could actually come in at 9:45, but you don't have to, as long as the paperwork.
Okay, and we'll get a notice of that new hearing date if they.
Yes, you will.
Okay, thank you, Your Honor.
November 17th at 9:45 a.m. And a notice will be sent out regarding that day. That's for review.
Okay, thank you.
All right,
Thank you.
Yep. Good day.
And, Christian, come get me off of it.
Just end the meeting. Just end it. Just
Okay,
say
thank you.
So that rival, or whatever, that was running all morning, right?
Yeah. It was a older gentleman. I don't know. He probably was in the wrong car.
Yeah, I saw him sitting up there, then he disappeared.
Mhm.
And you were calling out for him, so.
Looked like he was connected, but he couldn't, he didn't know how to work it.
Okay.
Hey, Deborah.